morning. Welcome to Law Moment. I'm Hallie Zobel with Private Corporate Counsel. We're attorneys in the state of Florida. We can be reached at 407-647-7887. Email hzobel@pcc.law. We're going to start this morning with a trivia question. Do you know who the Queen of Soul is? I hope you know the answer. One of my favorite singers, Aretha Franklin of Detroit, Michigan. The world lost her back in 2018. She was just 76 years old and she died of a rare form of cancer. Right now, a jury trial is taking place in Michigan, a will contest between three of her four sons. Her loss was a great loss to the musical world, to America, and to the world at large. People so greatly enjoyed her singing, as I did too. Well, the story starts when a niece of hers, Miss Owens, was appointed representative in her probate matter, and she found a couple of wills, and one of the wills was found under a cushion in the couch. And another will was found in the locked cabinet at Ms. Franklin's home. The parties went to mediation to try to settle their dispute before jury trials. Now, most courts make you go to mediation, and mediation is just a chance for both opposing parties to come together and meet with a third party, a mediator, who attempts to settle the issues so you can have control of the matter and settle it for what you want, and keeping the matter from going to court. This keeps a judge from making a random decision that may not be favorable to you or may be favorable. Now, we have several attorneys at our office here who handle mediations. So let's look at the assets and incomes of Miss Franklin's estate. A public accounting was filed just in March and showed the last 12 months the estate showed income of $3.9 million. Can you imagine that? And guess what the attorney's fees were? They're right now over $900,000. Let's look at her assets. Her assets, only just cash and real estate, is $4.1 million. What they haven't valued yet is that intellectual property, her musical royalties, and that is what brings value and is the value in her estate. So the news coverage tells us that a fourth son is not fighting in the estate, that he has special needs and he's under a guardianship with the court. And the issue is between a 2010 will and a 2014 will. Now, these wills, believe it or not, were in her own handwriting. These wills were not typed up. That's very unusual in this day and age. Now, I don't know Michigan law, but I do know Florida law, and generally a handwritten will is not permitted in Florida law or accepted in the courts. It's called a holographic will. So if you hear that term in a trivia contest, you know that's a handwritten will. Now, if it was valid in another state but doesn't have witnesses, it's not going to be valid in Florida. So let's review what the requirements are for a Florida will. It must be in writing. It must be signed at the end and witnessed by two people who have also signed it. Now, about this time, you coffee drinkers are rolling your eyes and saying, hey, I don't have millions of dollars in assets. Why does that attorney say I need a will? That's silly. Actually, you do. You can be specific in a last will and testament as to who you want to take your assets. If you do not, you are leaving it up to the state of Florida to determine who your beneficiaries are. I don't recommend that. Your beneficiary could end up being your half-sister that you don't even like. She could end up taking your inheritance. We can help. We practice throughout the state of Florida. So call us today. We represent business owners, get their estate plan in order, individuals. Email me at hzobel@pcc.law, 407-647-7887. See you at the law firm.